According to Max Weber Rational Legal Authority, it is based on clearly written laws, regulations, and procedures which are enforced by duly authorized public officials. Obedience under this system is not based on tradition or personal loyalty, but on the rule of law. This means decision-making must go through proper legal channels, reflecting a structured and impersonal system of governance. According to the Oxford English Dictionary, freedom is defined as the state of being free from servitude, constraint, or inhibition. In Malaysia, Article 10(1)(a) of the Federal Constitution (FC) guarantees that every citizen has the right to freedom of speech and expression. In fact, it is granted, protected, and enforced by law. However, this right is not absolute. Article 10(2)(a) allows for reasonable restrictions under certain conditions, such as public order and morality. The Communications and Multimedia Act 1998 CMA 1998 was enacted to regulate the communications and multimedia industries in Malaysia. Its purpose is to ensure orderly conduct and responsible use of digital platforms, especially in the age of rapid technological convergence. Section 233, under Part 10, Chapter 2 of the CMA 1998, deals with improper use of network facilities. This provision aims to protect public order, national harmony, and online civility by punishing harmful online behavior. Malaysia's legal framework balances freedom of speech with necessary restrictions. The federal constitution protects this right, while the CMA 1998 sets legal boundaries. Enforcement is carried out through institutions like the MCMC, ensuring decisions follow codified laws rather than personal bias. This reflects a rational legal authority, where governance operates based on established rules rather than discretion.
There is a landmark case which is Muhammad Fahmi Reza bin Muhammad Zarin against Pendakwa Raya 2020. Also, there are two recent cases which are Teo Koyang against Public Prosecutor 2022 and Public Prosecutor against Sarjun Hoda bin Abdul Hassan 2022.
Firstly, the landmark case we will discuss on is Mohd Fahmi Reza bin Mohd Zarin v Pendakwa Raya 2020. On Monday, the 8th of February 2016, at approximately 12:31 p.m., Mohd Fahmi Reza, a political graphic designer and activist, uploaded a graphic communication to his Facebook profile, Fahmi Reza. The communication mimicked an MCMC warning notice and warned the public to stop sharing edited images of national leaders as clowns. It stated that such actions were an offense under Section 233 of the Communications and Multimedia Act 1998, carrying penalties of Rm50,000 fine and or up to 1 year imprisonment. The message was read at 2:40 p.m. the same day at Seraya SDN BHD, Batu 3, Jalan Jelapan, Ipoh, Perak. For this, Fahmi was charged under Section 233(1)(a) of the CMA 1998 for knowingly initiating a false communication with intent to annoy others. He was convicted by the Sessions Court, sentenced to 1 month imprisonment and a Rm30,000 fine. Fahmi appealed to the High Court, challenging both the conviction and the sentence. Now, the issues of the case are whether the uploaded communication was false in nature, whether the communication was made with the intent to annoy others, and whether the communication is protected under freedom of speech as a form of parody or satire. In deciding the case, the court referred to several key precedents such as Ong Eng Guan v PP, 1956, 1 MLJ 44, which stated, "The point is not whether he annoyed the complainant, but whether he intended to annoy him." Next, PPV Rutinin Suhaiman, 2013, 2 CLJ for 27 mentioned that intent to annoy can be inferred and there is no need to prove actual annoyance or bring the victim to court. Moreover, Sepakat Effective v Menteri Dalam Negeri, 2015, 2 CLJ 328 said parody must meet the test of dual recognition and that it is both like and unlike the original. Lastly, People v Raphael Golb, 2013, New York claimed that parody is not protected if it causes harm through deception or fails to clearly signal it is parody. Moving on, the ratio decidendi is Fahmi admitted to designing and uploading the graphic. He argued that it was a parody, political satire criticizing censorship and the restriction of internet freedom, and therefore a valid expression of free speech. However, the court disagreed. It held that freedom of expression does not mean freedom from legal consequences when the communication has the intent to annoy or is false in nature. The court concluded that while Fahmi's views are not criminal, once those views were manifested as a public communication, they became subject to the law, particularly Section 233(1)(a) of the CMA. The court found that the communication was false because it appeared to be from MCMC but was not, was intended to annoy government agencies like MCMC and PDRM. It failed to meet the legal threshold for parody, and was not protected under the federal constitution. Importantly, the court emphasized that intent can be inferred. It's not necessary for someone to actually feel annoyed, as what matters is that the communication had the tendency to cause annoyance. In the end, the High Court affirmed the conviction that the offense under Section 233(1)(a) CMA 1998 was proven beyond reasonable doubt, but allowed the appeal on sentencing and reduced his punishment from 1 month jail plus Rm 30,000 fine to just a Rm 10,000 fine, with 1 month imprisonment only if unpaid. That's all from this case. Thank you.
So, the next case we'll be discuss is Teo Ka-yong against Public Prosecutor 2022. In this case, there are two main charities. One is the appellant, Teo Ka-yong. Another one is the judge, Nur Hayati Mat JC. Patrick Teo, also known as a well-known radio and TV personality in Malaysia. On the 8th of May, 2020, he posted offensive statement against the TMJ on his Facebook account, Patrick Teo, at 5 o'clock with intent to annoy others in Johor. The offensive comments included: "Can anyone work out what this Prince Flair is trying to achieve with his video? If your initial reaction to watching is what the fuck, you are spot on. Nyama." With the intention to hurt others' feelings. Soon, he was charged with improper use of the network facilities by knowingly making and initiating the communication of offensive statement against the TMJ under Section 233 subsection 1 paragraph 4 of the Communications and Multimedia Act 1998, with the offense punishable under the same act. He filed a notice of application at the Session Court, Johor Bahru on the 8th of September 2020 to refer a constitutional question to the High Court pursuant to Section 30 of the Court of Judicature Act. His application was dismissed by the Session Court Judge, SCJ, on 17 November 2021, thus this instant appeal. The issue is whether Sections 233 subsection 1 paragraph A and Section 233 subsection 3 of the Communication and Multimedia Act 1998 are uncertain, broad, and vague, inconsistent with Article 10 of the Federal Constitution, and are therefore null, void and unconstitutional. By this, the court held that the grounds presented by the appellant, arguing that the charge under Section 233 of CMA 1998 was uncertain, broad, and vague and therefore inconsistent with the federal constitution were without merit and invalid. The court held this because freedom of speech with the Article 10 Clause 1 Paragraph 4 of FC is not absolute, and there is an exception stated under Article 10 Clause 2 of FC. In the meantime, Section 233 of CMA 1998 provides the restriction to ensure public order by criminalizing the misuse of network facilities, particularly for the transmission of communications that intends to annoy others. Besides, Section 233 of CMA 1998 passed the proportionality test and is reasonably clarified. So, the charge preferred against the appellant was clear and specific. The alleged acts to have been committed were clearly stated and are sufficient for the appellant to understand the offense against him and to prepare his defense. This case was bound to follow the decision made in Yi Hung Seong against Public Prosecutor 2005. In this case, the court held that Section 233 of CMA 1998 was not vague as it was clear and specific and contained sufficient particulars of the alleged violation. Moreover, the judge, Nur Hisyam and Cyril Amar, the question raised was answered by the judges who held that the restriction under Section 233 of CMA 1998 was reasonable, justified and proportionate to the legislative objectives. As a result, the court disallowed the application on the grounds and the appeal dismissed. That is all for this case, thank you.
Public Prosecutor against Sarajun Hoda bin Abdul Hassan 2022.
On the 26th of April 2021, a social activist, Sarajun Hoda, was alleged to have posted a comment on Facebook that contained content considered as offensive, indecent and likely to hurt the feelings of others, particularly the Muslims. The post included suggestions to revoke Islam as the official religion, reform institutions like JAKIM, which is an acronym for the Department of Islamic Development Malaysia, and restructure national policies related to the religion. As a result, he has then been charged under Section 233 subsection 1 para A of the CMA 1998, which criminalizes the use of network services to transmit communication that is obscene, indecent, false, menacing or offensive with intent to annoy, abuse, threaten or harass. He then tried to challenge the constitutionality of Section 233 subsection 1 para A. He argued that the section violated his right to freedom of speech under Article 10 Clause 1 para A. The law bans the posting or sending of indecent, offensive, or false content if the intent is to annoy someone. He claimed the wording was too vague and too broad, and that it unfairly restricted free speech. He also tried to compare this to the Indian case, Shreya Singhal against Union of India. But the Malaysian court rejected the comparison, saying that Malaysia's legal and social background is very different. The main issue of this case is whether Section 233 subsection 1 para A and Section 233 subsection 3 of the CMA 1998 are unconstitutional for being vague, overbroad, and violating the right to freedom of speech under Article 10 of the Federal Constitution. In the end, the court dismissed the constitutional challenge, and the case was allowed to proceed to trial. This is because the law clearly defines the prohibited acts, and includes the requirement of intent, which gives sufficient guidance. Freedom of speech is not absolute and can be restricted reasonably. For public order and morality, the court held that the provision was constitutional and was reasonable and proportionate and within the constitutional limits under Article 10 Clause 2 para A. Cited Malaysian case law and rejected comparison with the Indian case Shreya Singhal as irrelevant in Malaysia's legal context. The court upheld the presumption of constitutionality, emphasizing that Parliament has the power to enact laws regulating communication under Article 74 and the Federal List unless clearly proven otherwise. Section 233 includes specific terms, like indecent, offensive, false, and requires intent to annoy, abuse and so on. Therefore, Section 233 is not vague. The restriction imposed is reasonable and proportionate under Article 10 Clause 2 para A, because it aims to preserve public order and morality, especially in a multi-religious society. Freedom of speech in Malaysia is not absolute and Section 233 operates within acceptable constitutional limits. For the presumption of constitutionality, in the case of Loh Kui Chun against Government of Malaysia, laws passed by Parliament are presumed constitutional unless proven otherwise, while for the reasonable limits on freedom of speech. In the case of Sivarasa Rajab against Badan Peguam Malaysia, freedom of speech under Article 10 Clause 2 para A is not absolute and can be restricted reasonably and proportionately under Article 10 Clause 2 para A. Constitutional rights can be restricted if the law serves a legitimate purpose and is proportionate. Then, in the case of Nur Hisham Osman against Public Prosecutor, Section 233 is specific and reasonable, which already upheld in previous case, which show that Section 233 already deemed valid. In the case of Mat Shuhaimi bin Shofi against Pendakwa Raya, it showed the burden of proof on applicant. The applicant must prove unconstitutionality, while in this case, he failed. The proportionality test upheld show in case of Public Prosecutor against Azmi Shorong. Section 233 passed the test in which the restriction was connected to legitimate public interest.
As a conclusion,
Section 233 uses vague terms like offensive and annoy, which are subjective and create legal uncertainty. Plus, the lack of clear prosecutorial guidelines raises concerns about fairness in enforcement. The wording should be more precise. For instance, using grossly offensive as proposed in the 2023 Amendment Bill, the Attorney General's chambers should also issue prosecutorial guidelines to ensure consistent and fair decisions. Freedom of speech is a right, but it must be balanced with public order. Section 233 of CMA 1998 helps regulate online harm, but clearer wording and enforcement are key. That's how rational legal authority works, through law, institutions, and fairness. Thank you.